Office of Tax Appeals. I am Judge Long, and this is a hearing in the appeal of Seibles. We're not on the record yet, and we're not yet live streaming, so I'm just going to go through some administrative items first. Please note that the proceedings will be live streamed, so please don't share any information that you would not want shared on a live stream. So this hearing is being held under the small case program, so I will be the sole ALJ deciding this matter. Also present is our stenographer, Ms. Rodriguez, who is reporting the hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks clearly and loudly, and when needed, Ms. Rodriguez will stop the hearing process to ask for clarification. We ask that you please speak one at a time and do not speak over one another. After the hearing, Ms. Rodriguez will produce the official hearing transcript, which will be available on the Office of Tax Appeals' website. The hearing transcript and a video recording of the hearing are part of the public record, so please remember these proceedings are being broadcast on our YouTube channel, and any information shared during the hearing can be heard and viewed by the public. So at this point, I'm going to ask whether either party has any new exhibits in addition to the ones we discussed at the pre-hearing conference. So I'm going to start with Franchise Tax Board. No. All right. And Mr. Seibles? All right. And then Mr. Seibles, do you still intend to testify as a witness? So let me explain what that means. So that means that when you share information, it could be considered as facts, as opposed to if you don't want to testify as a witness, that means it's considered argument. So you can offer argument and facts or just argument. It's up to you. If you decide to testify as a witness, that means that Franchise Tax Board can go ahead and ask you questions about your testimony. All right. So that just means that when we go on the record, I'm going to swear you in. It's a very simple script. Okay. So with that, do we have any questions from either? Oh, I'm actually going to go ahead and have us do a little mic check. It took me a second to get mine working. So when you have to wait for the, when you push it, look for a green, there you go. You can see the green light. Green light means that you're on.
Check, check.
Yeah.
Okay.
You want to do yours too? See, it takes a second. There you go.
Check.
Okay.
Check.
Yes, and when you're not speaking, go ahead and press the button so that it turns red. There you go. So it just takes a second. So if you can, when you're speaking on the record, you want to go ahead and just make sure you've got the green light. All right, do we have any questions before we go on the record from either party? No? All right. In that case, Ms. Rodriguez, all right, and we're ready to go on the record. Okay, with that, we are on the record. We are opening the record in the appeal of Seibles, OTA case number 240416003. This matter is being held before the Office of Tax Appeals in Sacramento, California. Today's date is Wednesday, February 19th, and the time is approximately 10:52 a.m. I am Judge Long, and this hearing is being heard under the small case program, so I will be the administrative law judge deciding the case. As a reminder, the Office of Tax Appeals is not a court, it's an independent appeals body, and the office is staffed by tax experts and is independent of the state's tax agencies. With that, I'm going to ask the parties to please introduce themselves for the record, starting with Franchise Tax Board.
Sarah Fassett for Franchise Tax Board.
And then appellant, please.
Good morning. My name is Mark Seibles, owner-operator of Livewire Installations. Mark Seibles, S-E-I-B as in boy, L-E-S. K.
All right, so as confirmed at the pre-hearing conference and in my minutes and orders following that conference, the issue to be decided in this appeal is whether Mr. Seibles' claim for refund is barred by the statute of limitations. Actually, let me restate that, it's in the plural. Whether Mr. Seibles' claims for refund are barred by the statute of limitations. And next, I'd like to move on to the evidence in this appeals. Mr. Seibles submitted exhibits 1 through 3. At the pre-hearing conference, Franchise Tax Board stated that it had no objection to Mr. Seibles' exhibits. They are now admitted into the record. At the pre-hearing conference, FTB submitted exhibits A through M. Mr. Seibles received copies of the exhibits after the pre-hearing conference and was provided with the opportunity to object, but no objection was filed. So I want to confirm, Mr. Seibles, you have no objection to FTB's exhibits being admitted?
Correct.
All right, thank you. Accordingly, FTB's exhibits A through M are now admitted and entered into the record. Now I'm going to go over the order of the proceedings today. In my minutes and orders, I indicated that Mr. Seibles would have 5 minutes for presentation, including witness testimony, and then FTB will have 10 minutes for its presentation, and then Mr. Seibles will have 5 minutes for a rebuttal. Next, I believe Mr. Seibles indicated he will be testifying as a witness, so I'm going to swear him in. Mr. Seibles, can you please stand and raise your right hand? Do you swear in accordance with OTA's regulations to accept, I will swear you in accordance with OTA's regulations and to accept your statements as evidence. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. All right, Mr. Seibles, you can go ahead and be seated, and you may begin your presentation when you are ready. You have 5 minutes.
Okay, like I said, good morning. My name is Mark Seibles. I'm the sole owner and operator of Live Wire Installations. I'm a low voltage wiring contractor. I'm sure you're familiar with the challenges of being an entrepreneur. Every task is on me: marketing, sales, design, install, service, not to mention the admin side, licensing, taxes. It's a lot for one person to handle. I'm currently trying to catch up on my back taxes. I'm here because I actually overpaid on these taxes. I'm not asking for a refund, rather credit on my account. I'm still in business, and I'm just trying to get all my accounts current. And that's pretty much that's all I have. Oh, one more thing. Actually, what happened about a month, maybe 2 months ago, is my wife she was hit with a levy on her checks from her job, and I know we're just married. That's kind of part of the process, but it's not. I don't feel. For me, I didn't feel it was fair for her to have to suffer for something that I did solely. So I'm just trying to make everything right. I'm just trying to get back even, and I'm just trying to get my accounts all squared away. Thank you.
All right, thank you. Give me just a moment here. I want to check something in the exhibits. All right, Mr. Seibles, I just want to confirm that you and your spouse filed married filing joint.
We do.
All right, thank you. I don't have any questions for you about your testimony right now. I will ask Franchise Tax Board, do you have any questions for Mr. Seibles about his testimony?
I do not, thank you.
All right, in that case, I'll go ahead and give Franchise Tax Board the opportunity to present its argument. You may begin when you're ready.
Great, thank you. Good morning. My name is Sarah Fassett, and I represent Respondent Franchise Tax Board in this matter. The sole issue on appeal today is whether appellant's claims for refund for the 2012 through the 2014 tax years are barred by the statute of limitations. Respondent received information indicating that the appellant earned income in a sufficient amount to create a filing requirement during the tax years at issue. However, respondent had no records of appellant filing California income tax returns for those years. Respondent issued a demand for tax return for each year at issue, requesting that an appellant either file his tax returns or explain why he did not have a filing requirement. When no response was received for any tax year, notices of proposed assessment, or NPAs, were issued to the appellant, which included penalties which were correctly calculated and imposed. When an appellant did not protest any of the NPAs went final and the balances became due and payable. For all 3 tax years, FTB collected payments through billing and collection efforts. Respondent received appellant's 2012 through 2014 California tax returns on February 15th, 2024. Respondent accepted the returns as filed, reduced the imposed penalties to correspond with the reported tax, and applied the payments made pursuant to the collection action, resulting in overpayments. Respondent treated the tax returns as claims for refund and denied the claims because they were all filed after the statute of limitations had expired. California law imposes strict time limits and other requirements for filing refund claims, including tax returns that claim refunds. And there is no waiver of the statutory period for refund claims based on reasonable cause type arguments. Appellant did not file timely returns for any of the tax years at issue. Therefore, his claims for refund must have been filed either within 4 years from the original due date of the return or 1 year from the last overpayments. As laid out in respondent's opening brief, appellant's claims for refund were filed on February 15th, 2024, and accordingly, none of the claims for refund were timely and correctly filed and correctly disallowed as both refunds or credits. I'm happy to answer any questions you may have. Thank you.
All right, thank you, Franchise Tax Board. I do not have any questions at this time. I am going to go ahead and let Mr. Seibles begin his rebuttal whenever he's ready.
This is the closing arguments.
Yes, that's correct. Any final points you'd like to make? This is your opportunity.
In closing, I'd just like to say that I just hope that the money that I overpaid has not gone to waste. I'm a contractor. I've never worked in an office. I'm always on the job site every day. So I'm still learning. This is something new to me as far as all the paperwork. The admin side of the business is totally different from what I do. I specialize in the field, building things, wiring things. And so I may have to hire somebody to handle my admin side, my bookkeeping side. But I'm just trying to figure this thing out, basically. And I was also being an entrepreneur. Day to day is always different. You may get a job today. You may not get a job for 2 more weeks. But the mortgage stays the same. So yeah, I have to kind of prioritize, the bills. And unfortunately, this is one that I let go for way too long. And I'm trying to get back on top of it and stay current. Thank you.
All right, thank you. With that, I don't have any questions for either party. Does anyone have any questions or comments before we close the record? Okay, it looks like we do not. With that, I'm ready to conclude this hearing. I want to thank both parties for attending today and for their case presentations. I'm going to decide this case based on the arguments, the evidence, and the testimony in the record. I will issue a written decision no later than 100 days from today. This case is submitted and the record is now closed, and this also concludes our hearing calendar for the day. Thank you both.